Excellent. Thank you very much. Welcome, everybody. Thanks for joining us today. This has been a great series of virtual roundtables that we had, and I'm sure that those returning participants recognize my voice from some of the other ones. You won't hear it as much today. We have a great discussion that's going to be happening today with surrounding prosecution, and Jane's here, and I know you've heard her voice as well. I'm going to let the presenters introduce themselves, and then I'm going to do my best not to continually talk like I typically do. Is that okay with you, Jane?
Thanks, Mike.
This is going to be the hardest thing I've ever done in my life, but I'm going to make it happen. But I'm really excited about this conversation. This is a conversation that we don't really oftentimes have the opportunity to have, and to have this platform to bring everybody together talking about this. So it's going to be just as exciting to me as it is for everybody else on the call as well. And I look forward to chiming in a little. So I'll turn it over to you, Jane. And
Thanks, Michael. This is Jane Anderson. I'm an attorney advisor with Equitas. We provide training and technical support to prosecutors and allied professionals around the country. And really our mission is to support those that are doing the work on the ground, investigating and prosecuting and supporting victims of domestic violence, stalking, sexual violence, and human trafficking. I'm a former prosecutor out of Miami-Dade County, where I spent most of my career prosecuting just those types of crimes. Tried a lot of cases, went through a lot of ways to do voir dire, tried this and tried that, and have had some successes and some not so successes. So happy to have those conversations today. Mike, just in case not everybody knows the world-famous Detective Mike Riviere and his Boston accent, would you mind giving them a little bit of background?
all right, you asked for it, Jane. Yes, Mike Riviere, I was with the Salem Police Department a little over 32 years, heading up the Victim Services Unit. I've done a lot of work nationally with NEWAP and Jane and all the other presenters in the training team, and I've just been fortunate enough to get around the country and try to make a difference and spread the word and have the conversations with everybody. And a very special thank you to OBW for allowing this to happen. And you know, they're the funders. They're the ones that give us the opportunity to get on this platform, and it's important to recognize all the work that they've done in this area as well. So, thank you, Jane.
Thanks, Mike. Elliot?
Good afternoon. My name is Elliot Casey. I was a prosecutor as well for 15 years. I served as a prosecutor in Alexandria, Virginia. I was cross-designated in Arlington, did cases in Arlington as well. I was a prosecutor in Albemarle County, Virginia, which is, for those of you who don't know what Albemarle is, it's basically the county that surrounds the city of Charlottesville. I think everybody knows Charlottesville now, in Commonwealth, Virginia. And then I was also a special assistant United States attorney for most of that time in the Western District of Virginia, and did cases involving violent crimes and so on in the Western District. But most of my time, 99% of my time, I spent in state court doing everything from driving on suspended to homicide and everything in between. And I've been working with NEWAP for several years now, traveling around and training, and I'm excited to be here today and talk about how we can better serve this population of victims in our communities.
Thanks. We're also super excited to have Charlotte Jackson available.
Thank you, Jane. My name is Charlotte Jackson. I'm the Domestic Violence and Sexual Assault Resource Prosecutor for the Prosecuting Attorneys Council of Georgia. I have been a prosecutor for over 20 years. I've spent most of my career prosecuting cases in the city of Atlanta at the Fulton County District Attorney's Office, where basically I've prosecuted everything that came in the door. I joined the Prosecuting Attorneys Council. I developed and I specialize in domestic violence and sexual assault crimes. I train on trial advocacy, law enforcement response. I'm an expert on crime victims' rights, and I also prosecute cases throughout the state of Georgia, and so I have been able to develop some pretty good experience prosecuting cases, not just in large metropolitan areas, but also in rural areas. And thank you for having me.
And I think Mike gave it away that, you know, we're supported by the Office on Violence Against Women. The Department of Justice supports this work, and it's incredibly helpful for us to do this work with their support. but of course, everything that we say today is not necessarily reflect their views. So what we see, you guys are already kind of letting us know where you're from, which is great. And I didn't actually even realize until we were talking about where we all prosecuted that we're all very sort of one quarter of the country. But all of us have a really wide national perspective as well based on our work with our current jobs. And so share with us what's happening. Everyone is coming in really widely from across the state, and they're saying hi to each other and their neighbors. Oh, we've got somebody from Miami. Wonderful. And let's see. Let's get this going. Who is here? Let us know how you would best describe yourself, what your discipline is. If it's something that's not there, go ahead and type it in the chat box. And we really do generally invite such a multidisciplinary audience because we know it's so key to this work. I will warn those of you that are not prosecutors that this particular roundtable is going to be a little prosecution focused. But I think those of you that work with victims in any way, it's always good to know how the whole system is put together and how everything works, right? Because you're going to be sometimes the front line to explain that to the victims you're working with. And additionally, all of the materials that we provide in this recording is something that we invite you to share. So if you're working with prosecutors that couldn't pop on today, feel free to share these materials. At Equitas, I have some additional voir dire questions that I thought just as we were getting started, I was like, oh, maybe I should let them know about those too, because they're not specific to immigrant victims, but they'd probably still be something that would be useful, and I'm happy to share those. So we've got about 50% of you guys are working either in a law enforcement agency or a prosecutor's office, serving as that victim advocate. Wonderful. We've got about 38%. Yeah, I think that's kind of on the high side for the number of prosecutors we usually get in here. So I'm happy to see that. Welcome. Some program coordinators. Excellent. Feel free to keep those answers coming as we move along, but it's great to see who we've got in the room. Mike, unfortunately, none of your partners have come in. Always,
that's a big change.
Always looking for an opportunity to sort of give a jab there, Mike. Sorry. So this is sort of a foundational quote. It's from the U.S. Supreme Court back in 1895, Connors v. U.S. And what the court says is that this suitable inquiry, right, what we refer to as voir dire or jury selection or voir dire, depending on where you are, that this inquiry is really made so that we can ascertain whether jurors have any biases, opinions, or prejudices that are going to affect or control how this case is determined, and that we have a right to make this inquiry because we want a fair determination. And that inquiry is supervised by the court. And this is the part that always makes it hard to train on the topic, because the Supreme Court has left and says that every court has, by necessity, sound discretion of how they're going to oversee this inquiry, right? So voir dire varies widely. I mean, in my experience, it's not only state by state, county by county, courtroom by courtroom, judge on Monday versus judge on Wednesday, and even the type of case that you're determining, right? So a judge may give a lot of leeway in a homicide case, no leeway in a drug possession case. So we have to be really prepared to be flexible and to think about, even within the structures that the court is going to hold us to, how we can achieve the overreaching goals that we have to do this jury selection. So we are available, and other folks that we have in our network are available for any case-specific assistance. I'd say that a lot of my consultations are exactly on this topic, which is sort of serving as that sounding board of how am I going to conduct an effective voir dire, because we know it is setting the stage for the rest of our case. So we're available for that case-specific assistance, but always be trying to think about how you can adapt strategies within the confines of your courtroom, and maybe try to push those boundaries by using case law, by using research, and those are things that we can help build for you as well. And I know one of the things that's in the in that box for you to download, it's called voir dire-generally.pdf. That's just a couple of slides that are chock full with some really great case law that could support maybe arguments you may have. Okay, so before we even start voir dire, we've got to sort of analyze our case. And this is sort of where I want to start with for us, because sometimes I feel that we have a knee-jerk reaction of when we have something that we might consider problematic. We have this problematic fact or situation in our case, and we try to figure out how to not talk about it, how to sanitize our case. And I think when we're working with cases involving immigrant victims, it's going to be very hard to sanitize that case. And we have to think about why we want to sanitize it in the first place, right? So these are sort of ways for us to be thinking about our case, not from the position of being on the defense, but from the position of being on the offense. So what we know when we talk about domestic violence, sexual violence, stalking, human trafficking cases that involved victims that are immigrants, we know that this is oftentimes on purpose. This is the offender's plan, right? And it's for one of these three reasons. One is that they have chosen that victim on purpose because they feel that that victim is somebody that they can exploit and victimize without ever being held accountable, right? This is a real or a perceived vulnerability that they want to exploit, right? So that type of victim selection is often going to be part of our case. And so we want to be talking about that in an offender-focused way. Not what the victim did, but why the offender picked that victim. Picked that victim so that police would not believe them. They'd be too afraid to go to the police. The jury wouldn't believe them. They wouldn't have access to services or wouldn't think they have access to services. So that's one of the things we want to think about. The other one is the criminal act itself. Did the offender use the victim's immigration status to actually commit one of the elements of the crime, or perhaps motive as well? So is it integral to how we're even proving our case? And oftentimes the answer is going to be yes. They used the immigration status, precarious immigration status, as part of that power and control wheel. They made overt threats during the act of stalking, or perhaps through a coercive scheme in a human trafficking case. They were using immigration status, threats of deportation, all the collateral consequences of deportation, including financial instability, family separation, etc. And that made up an actual element of the crime, and therefore we need to talk about it there. And the last place where we see this in our cases is whether the offender escaped detection because of this, right? So we know in a lot of our cases, immigrant victim or not, we're going to have this delayed disclosure, right? Or we're going to have a victim that appears to be participatory and then at some point is unable to participate and then is cooperative again and then is unable to participate, right? That roller coaster that we're all probably very familiar with. That's part of the offender's plan to escape detection. And who better to pick as your victim than someone that is not going to go to the police, is fearful of the police, is afraid that if they cooperate, they're going to be deported. And all of those things are on top of those dynamics that we know happen in every case of domestic violence, sexual violence, stalking, and human trafficking. So this is a great way to sort of like start analyzing our case and thinking about where this piece, this immigration piece that we may think is scary and hard to talk about, where it actually fits in our case. And I think in most circumstances, we realize, hey, we're going to want to talk about it. Let's turn this around. What may seem originally like a challenge, now let's use it for our benefit. So how do we do that in the context of setting the stage? So these are some of the general goals of jury selection. I'm sure that if we had asked this question to you and put it for you to put in the chat room, you would have guessed these, right? So some of them are very in line with what the Supreme Court says, right? Unbiased, uncover biases. But we have some other collateral things we want to do as well, right? We want to demonstrate leadership. We maybe want to manage expectations, establish trust so that when the jury has a question, they're looking to you for the answer. Instill empathy for victims that may not come off as, may not originally be perceived as being empathetic, maybe due to their immigration status. And then educate as best as we can too, so that when we walk into the courtroom with the jury selected, we've already laid a lot of that groundwork and they're seeing our case through the lens that we want them to see that evidence and that testimony. So it's a lot, Charla, and so I want you to kind of break it down, if you don't mind, and talk about how we can do some of these things.
Okay, I'm happy to. One of the things I think about what I'm doing voir dire is I am guided on the principle that our role as prosecutors is to do justice. And so when you're doing justice, you want to make sure that the defense has a fair trial, but you also have to understand that the state also has just as much right to fairness. And then also think about what our role is, and you want to be able to communicate that to the jurors. It's not the victim versus the defendant, it's the state versus the defendant. This shifts that focus in the way that Jane talked about it from what the victim's motives are and changes it to the state pursuing justice on behalf of all people. And so when you have that posture, it's much easier to then begin to educate your jury about your topic. And if you really do a great job of educating your jury, by the time you put your expert witness on the stand, they'll be shaking, nodding their heads. Yes, yes, okay, we understand it. Because you want to lay that groundwork so that when the expert witness testifies, they'll be able to relate it to something common in their lives. And so when you think about breaking down your case down into those facts, think about what those bias, myths, propaganda are that your jurors might believe in your case facts. Did your victim stay? Did your victim not report the crime immediately because your victim was afraid of the immigration status? And try to relate that in your voir dire questions to something that your jury could relate. And you may or may not draw an objection from the defense, but remember, state has a right to determine the bias of their potential jurors, and so that can be the basis for you asking your questions. And so, though you're going to talk about the immigration, really, you want to be knowledgeable about the immigration, but just like Jane said, using the immigration, the victim's immigration status to control the victim is just another tool in the batterer's toolbox to control their victim. And so one of the things is you want to be prepared with your standard domestic violence questions, and you might want to ask a juror, do you know someone who's been in a domestic violence relationship? Or do you know someone who's been in a difficult relationship with someone who had power over them? You know, it could be a boss. It could be a neighborhood bully. You can ask them, did you tell on that person right away? Well, why not? I was afraid. And then all the jurors start shaking their heads. This is something that they can understand, and that way you have uncovered the victim's vulnerability and tied it to something that jurors can relate to. You want to make sure that you're talking about, start laying the groundwork for explaining the things that can't be explained. You want to prepare your jurors for the fact that there are going to be some things that everyone may not understand and that they're going to hear from expert witnesses that will help them to make a decision based on the facts that they hear. And then finally, you want to talk about, explore their views about immigration. You want to manage their expectations. Just so that it's not something, by the time the defense brings it up, it's not a big deal. They already understand it. They know you're going to have an answer for it. If you act like it's a big deal that you should be afraid of, they're going to treat it that way, and you may end up with an acquittal. And I would wear it as a badge of honor. Once again, the immigration status is a weapon, just like the hands, the fist, the knife, or the gun, or whatever that your batterer used. And just like I would incorporate that into the general theme of my case, I would use that in the voir dire. You might ask questions like, we have some voir dire questions that we have added into the Dropbox, and you want to ask your jurors directly about their immigration status, preparing them that the case is going to include testimony about undocumented immigrants, and ask them directly, is there anyone who can't be fair and deliver a fair and impartial fair and impartial verdict because of the nature of this type of case? One question you want to make sure that you ask is about talking about the fact that illegal immigration is discussed in the media, and try to uncover your jury's feelings about their feelings or beliefs for or against the issue to find out if that would prevent them from being fair or impartial. And then you also might want to talk about the terms undocumented person versus a legal immigrant versus illegal, and some of that can be interchangeable from the perspective of where you are in your region. If you're in an area where there's lots of immigrants, it may not be as much of an issue. If you're in an area where there may not be as many people who may be immigrants or who may be undocumented, you may have to go more into that particular inquiry. Let me advance my slide. So you're managing the expectations by connecting it to something the victim did that any juror might do in a different situation. You might want to act directly. Do you believe that victims of crime deserve to be victims of crime because of their status? And you might switch it out of, other than being an immigrant, there might be something else. Do you believe that because a disabled person is more vulnerable, that they should be a victim of a crime? Does that make whatever happened to them okay? Finally, you want to instill empathy for your victim. And the first place this starts is with the empathy that you have for your victim. If you're standoffish, if you're uncomfortable with being empathetic with your victim, juries will pick up on it through your body language, your tone of voice, et cetera, and it may translate into a difficult time for your case. And so you want to talk about what those vulnerabilities are to try to uncover those, just like you would with any other case. Sometimes what you can do, for example, if you were going to ask that question, if you know anyone who's been the victim of a crime, you might want to, whether or not, you may think that this person on the jury panel may be struck because of their bias, but you can, while they're there, you can actually use that juror to educate your other jurors. So if you have a victim of domestic violence, or you have someone that is an immigrant, you might ask them about their experiences, ask them about whether or not they left, if they're victims of domestic violence or sexual assault. Did they report it immediately? Did they leave their abuser? Get them to explain why they did what they did. And they can be used to educate your jurors, and then that way you can come back in closing and relate. Many of you have related that you're have experience with this, or this is just like any other person, and that takes the stress off of your victim. And then finally, jurors, people serve on the jury because they want to do what's good. They want to, I believe that people's hearts, people are generally good. People want to help other members of their community. They want to do what's right. And people generally, by the time they go through voir dire, they want to do what's right, do justice, uphold the rule of law, and that is one of the best parts of our system. Our belief that we want to uphold the rule of law, which is part of the American dream. And so you want to also explore that theme with your jurors, talking to them about why people come to the United States. They're immigrants on your jury panel. Talk to them about why it's important that the law apply equally to everyone, whether or not they believe it's true that the law should apply equally to everyone, whether or not they believe that only the powerful and the connected should be protected by the court system and by the rule of law. This helps to bring out those things and connection that we all have together as citizens, and this is another way of helping to connect that jury to doing what's right in your case. So, Elliot, what do you think?
Oh, sorry.
Oop. Yeah, I think what Charla said, as always, is so directly on point. And where are we here? Okay. Is so directly on point. And uncovering that bias is the most difficult thing about voir dire because, you know, as we all know, jurors are not necessarily going to be honest about their inherent biases. They're not necessarily going to be honest with you, even if they're aware of them, but they themselves might not be aware of them. And so what you're trying to figure out is, can I at least get someone to reveal an existing bias if they're aware of it, or if I can't, can I make them aware of the bias even though they don't realize that they have it? And this goes to what is the most, teaching this topic is very difficult because certainly there are 51 different sets of voir dire rules out there. There's 50 states and the federal government, and we, could easily sit down and talk about each state's rules. So we can talk about Virginia, and we can talk about Georgia and Massachusetts. And it is, in a lot of ways, very difficult to generalize. But one of the general rules that one of the ways you can generalize is that all voir dire is about uncovering, as Charlotte is indicating, these biases. And it's not necessarily about finding a jury that doesn't know anything at all, a completely blank slate jury, right? We can't get that jury, and that's not what voir dire has been about, at least not for the last 150 years in the United States. Under the jury system originally, in fact, going back to the days of the Magna Carta, the jurors were selected as people who knew about the case and who were brought in because of their knowledge. But wherever you are, I'm guessing that whether you're in Arizona or Washington State or Ohio, ultimately you are trying to find people who are going to judge judge this case based upon the facts that they hear in the courtroom and the laws they are instructed by the court. And when you're talking about cases involving immigrant victims, there's a lot of, with a little bit of knowledge comes a lot of bias, unfortunately, in our society. And that's true even when you have people who are familiar with and may have friends who are from immigrant communities. You may have people who, in fact, are Spanish-speaking on your jury, and they may believe they're very knowledgeable about the language, for example, and that can be problematic for you in your case, right? It can be problematic based upon where your victim comes from. For example, if you have a juror who comes from Puerto Rico and you have a victim who comes from Mexico, right? Delincuente, it means delinquent in Puerto Rico, but it means criminal in Mexico, right? Cancelar can mean to cancel something, or it can mean to pay something off. So they may, on the jury, be bringing with them what they think is a great deal of knowledge, and you're going to have to figure out, is that knowledge or is that bias, or does the knowledge that they have carry with it some bias that they may not even be aware of? Equally, then, people may think they know about the immigration system, either because they work with people who've been through the immigration system, or they themselves might have been through, might be immigrants or have immigrants, and they may not recognize that the system has changed. Indeed, the system's changed a lot over the last few years, and I'm sure, Leslie can talk about that. The director of NEWEP, she's been around since she's been doing this since the early 90s, and she's seen a lot of changes. So one of the things you're going to have to do is parse through, okay, who has knowledge here, but doing so with the sense of, your concern is not that that person has knowledge, but does that knowledge carry with it some kind of bias, right? Because that's your goal here, is to uncover the biases that will keep a person from judging the case based on the facts they hear in the courtroom and the laws they're instructed by the judge. It's crucial for your case to always be focused on the fact that the victim is not on trial. This is about an offender who is preying on this victim due to their vulnerability, and their vulnerability may, in fact, and the reason the offender has selected this victim is because of their immigration status potentially, or the immigration status has fed into their ability to use power and control over this victim. And that person, that victim, is entitled to equal protection of the law, as Charlotte talked about. That's part of the American dream, and that's why we have the system in place. But you're going to have jurors who simply do not view the system that way. And because of that, you have to figure out a way to uncover that. I would say part of the voir dire process, anyone's voir dire process nowadays, has to be social media research, because people may not be vocal about their feelings in the courtroom, but they're certainly willing to be vocal about it on social media. And I think most of you come from jurisdictions, I'm guessing, where you do have some ability to do voir dire, social media research during your voir dire process. The ABA has advised, and does have an advisory opinion 466, that says that as long as it is that that this person has public posts on social media that are available to anyone without you secretly friending them, that information is being shared and is open to the public. And you're probably not violating your version if you're a rule jurisdiction, Rule 3.5, because again, you're not directly communicating with the juror. So you're not violating the rules that say that you cannot communicate directly or indirectly with a juror. Again, you shouldn't be friending jurors, you shouldn't be reaching out to have contact with them, and you should be making sure that if you're having your paralegals do this, that they understand these rules, right? That, again, your rules, if you classify it as an 8.4 or 4.2 rule, there are lots of cases that you can look at. South Carolina has a good opinion. Is it improper for prosecutors to have lay members of his jury selection team obviously call jurors? Lawyers cannot use agents to do their dirty work for them. But again, this is something that you can do if it's public information. You can learn a lot about a juror and their views about whether or not the victim has assumed the risk by coming into this country, whether or not your victims are entitled to equal protection of the law. Google, Bing, People, PIPL.com, Yippee, these are search engines that you can use to search for your jurors. And of course, Facebook is a great tool. It's a horrible tool also, but it's a great tool. And at this point, I think over 200 million Americans, 200 million adults have Facebook. So you ought to be doing that kind of research. But once you get into the courtroom, then how do you effectively voir dire your jury to get them to be willing to talk about their biases, but at the same time use voir dire as a platform to overcome those biases as well, right? To make sure that they understand, to make this contract with you, that they are going to give your victim equal treatment under the law, that they're going to understand that your victim is entitled to the protection that they're receiving, especially if their victim is in a U visa or T visa program. People nowadays expect lawyers to be tricky, and in addition to that, you're a prosecutor, which means that you might have serious trust issues in your community nowadays versus maybe even the way it was 5 years ago or 10 years ago. When I started as a prosecutor, it was a lot different to walk into a courtroom than it is nowadays. And the level of trust that you receive as a prosecutor is a lot different in lots of communities. But the bottom line is anyone trust people if they are listening, if they're willing to listen, if they have authority but do not abuse it, if they speak in plain terms and speak clearly, and demonstrate command of the law, of the facts, and of the space that you're in, right? You've seen judges who are getting there and are, in your experience, I'm sure, who come in and they are brash and boisterous and loud, and they don't have credibility. And you've seen that judge who comes in and takes the bench, and they speak very quietly, and they never raise their voice, and they have absolute control of that courtroom, and that's what you want to be emulating, right? You want to be respectful. You don't want to hide from this information. But I think especially if you have an immigrant victim, too often we try to apologize for that, or we try to hide from that fact. We try to hide from the fact, especially if you have a victim who's receiving immigration relief because of their victimization, oftentimes that we feel like we need to hide or apologize for that. Oh, I don't want to, this is going to be a problem for me in my case. My victim's got a, U visa application applying. Now I'm going to figure out how to explain this to a jury, or how to argue it to the jury. And I think that's the wrong way to look at it. If the jury is going to see right through you if you are not being honest, if you're not being upfront, and if you're not owning the fact that the victim is seeking immigration relief because they don't want to be a victim anymore. They're tired of being victimized. You have to, for yourself, believe in this process and believe in the system. You don't have to belabor it. You don't have to patronize the jury. You don't have to treat them like they're idiots. But at the same time, and this goes back to something basic about voir dire for me, I never thank the jury. I never, tell them thank you for your service. It's their duty. It's my duty, and it's my job to come in here, and it's your job to come in here and hear this case because of what this person did to this victim, to this immigrant, to this innocent person. And I'm not going to apologize for protecting my victim and making sure that my victim is protected, and I'm certainly not going to apologize for the victim seeking to get out of this abusive relationship by taking away a weapon that was used by the offender to keep them from seeking protection, to keep them from leaving, to keep them from trying to get out of the situation. And so I think you need to confront that with the jurors, especially in these cases. I will be honest, I come from a place where, I'm trying what year it is now, so a little more than 10 years ago, I was very opposed to people getting U visa applications or receiving U visa or T visa applications before my case was over, because I did not want to have to deal with the perception in front of a jury that somebody was receiving something in exchange for their testimony. And so I didn't want people to be applying. I wanted that out of the way because I was afraid of that in front of a jury. And it really wasn't until I had a case involving a young child who had been sexually abused that I sort of came to realize that I was an absolute hypocrite, that I was judging people based upon their seeking immigration relief. At the same time, I had come from a white-collar background, and then I was doing drug cases. So in the white-collar background, everybody receives something in exchange for their cooperation with law enforcement. They get insurance relief. People are seeking insurance. They're maybe getting restitution in their cases, in white-collar cases. In drug cases, half my witnesses were getting paid or getting some kind of exchange for their testimony. And it never bothered me. I got in front of the jury and I said, yeah, sure, I don't mind. I don't mind that the person's getting paid. I don't mind the person's getting time off. It didn't bother me. And in these immigration cases, for some reason, I was terrified of creating a situation where I had to explain to the jury, well, here's something that the victim might be getting. And what I came to understand was that victims are not getting anything, and we're looking at it the wrong way. We're really doing a disservice to our victims. We're not giving them something. It's not like they're winning the lottery. What we're trying to do is protecting them and trying to take a weapon away from an offender who has used their immigration status as a tool of power and control. And so in voir dire then, especially since the defense is going to make this argument, you start with simple questions like, if you learn the victim couldn't live on their own, could not escape from the defendant because of their lack of legal status, would you refuse to listen to the victim if you learned that the government told her that, that she could be safe from deportation even if she left the defendant? Or does anybody here think the government shouldn't be able to provide a safe place for crime victims to flee if they're being exploited due to their lack of immigration status, right? And you're trying, and believe it or not, I think, and this is one of those things that shocked me the first time that I saw it in a voir dire, was you're going to have people who tell you, no, I don't think that people should get legal protection. And the first time that I saw it, I was in federal court, it was sort of an eye-opening experience for me because the jury had just gotten done telling me, this is 50 jurors from the Western District of Virginia, that they didn't have any problem. The question was asked, did anyone have a problem with the drug laws in the United States? We had drugs involved in the case, methamphetamine, and nobody raised their hand. And I was like, okay, well, at least I know that all 50 of these people are liars because I have a problem with the drug laws and I'm a prosecutor. So, but then the question was asked, okay, well, does anyone have a problem with the immigration laws? And does anyone have a problem with the fact that the defendant, for example, who didn't have status in the case, was entitled to the full panoply of constitutional rights that anybody else does? And literally like 12 people raised their hand. A dozen people in that jury said, yeah, I have a problem with the fact that this person's entitled to constitutional protections because the person is here unlawfully and they didn't believe the person was entitled to those protections. And so, you know, I think if you haven't had this conversation with your jurors, you may be surprised at how open they're willing to be, but also you may be surprised by some of the views they express. Because we're not at a point in our society where these views are completely, you know, hidden. I mean, I think it's different if you're trying to uncover a pure racial bias. You may not get somebody to admit to that in voir dire, but I think you will have people admit, yeah, I don't think that, you know, if you're here illegally, then you should just be deported. You shouldn't get any rights. And obviously you want to identify that person. You want to get that person off the jury. But in addition to that, I think you have an opportunity there to correct that. And you know, again, you're going to find here the responsibility of voir dire, the goal of voir dire is to remove prospective jurors who will not be able to follow the court's instructions and not judge the case based upon the evidence that you hear in the courtroom and the laws you're instructed by the judge. And so when you're uncovering these biases, what you're also going to be doing is trying to re-educate the jury in an effort to correct these problems, not just the jurors who've spoken up, but everybody in the jury as to what the true facts are in the case and why it is that they should believe the victim and not buy into the defense's garbage.
Thanks, Charla and Elliot. I think there was a couple of things I just wanted to follow up on, and one of them is this idea of asking the sort of something shy of, is anyone in this panel racist? Right? And trying to uncover.
Does that not work? I didn't realize that doesn't work, Jane. Sorry.
And so we've got some questions I'm going to open up to the field, but that's one of those things I think people sometimes have issues with. I think watching the body language of the jurors as well, so you're not just paying attention to the person that you're maybe having a one-on-one conversation with, if that's available, but if the rest of the panel is also in the room, checking out their body language. Again, every courtroom set up a little bit differently for that. And I know you were making a really good point, Elliot, but I just wanted to make sure it was clear that we should not in voir dire ever mention if the defendant is not is undocumented.
Oh yeah, I'm sorry. And so the case, the example that I gave in the federal court case, that was an element of the offense that I had to prove because he had a gun and he wasn't here lawfully. So it was going to come out because it was a matter of proof. I had to prove that. But Jane's exactly right. Unless it's an element of your offense that the defendant's not here lawfully, you probably don't want to do that.
Just wanted to clear that up before we move on. Thanks, Elliot.
Yeah, important safety tip, guys. Thank you.
So one of the other things that sort of to bookend this conversation before we get into the question and answer is another thing that we want to be walking into knowing about. Not only did we do that, you know, that analysis of our case where we figured out where is immigration really actually something I want to be talking about, and therefore how am I going to lay that foundation throughout the voir dire. But the other thing I want to be thinking about is my offender-focused theme. Charla did a great job of explaining that one of our jobs is to sort of already start reframing this issue. This trial is not about my victim. This trial is about the offender and what the offender did. And we know that in this type of case, in all cases, the defense really their goal is to put that spotlight on our victim, right? And in why the victim didn't leave, that the victim was a bad mother, that the victim maybe has a substance use disorder. Now we add to it that the victim is here without documentation. the victim isn't working or working illegally, in quotes. So we know that that's going to be the thrust of their mission, is take a spotlight and put it on our victim, saying, look at the bad victim. And our job, and we need to be doing this from the very, very beginning, is making sure that we are driving the narrative and that we are focusing that spotlight where it belongs, on the offender, what the offender did, why the offender picked that victim, what they did to control that victim, why they thought they were going to be able to escape accountability, right? And then you're telegraphing to the jury, you are the ones that are in the way of him escaping accountability. And so some of the ways that we do this is developing a theme. And sometimes we develop a theme and it kind of morphs throughout trial, or sometimes somebody says something in the middle of trial, like this beautiful phrase, and then all of a sudden that becomes your theme. I had a trafficking case where on cross-examination the victim said, you know, well, I thought he loved me, but if he loved me, would he have done this to me? Well, that was beautiful, and all of a sudden I was like, oh, that's my new theme. But it's good to come in with a plan, a game plan, because we can start using that theme in jury selection. So if you're looking at the slides, you've got a couple of themes here that could be appropriate in one of these cases, right? So one of the simplest ones, and sometimes, you know, these sound cheesy, but we know how effective they are because everyone knows the most famous theme ever used by an attorney in a criminal court of law. I'm going to have to see if anyone can type that into the chat, what the most famous theme ever used, very effective. We all still remember it today. I may not be giving you enough clues, but if you think you know what I'm talking about, write it in the chat room. But these themes can really help frame all of our evidence and all of our testimony. Rocio, you cheated. You know this. Preying on the most vulnerable, right? So thinking about using that theme, now you're trying to say, okay, offender is predator, victim is prey, she's prey, he's prey because of the vulnerability, because of the immigration. He picked this victim because of the immigration. So you're setting that stage. And you can start doing that in your voir dire. And so lots of kind of examples of how we can do that. I had a lot of leeway, so caveat there. I had judges that were pretty reasonable, and especially when I was able to articulate, like, hey, this isn't just, I'm not pre-trying my case. And even if I do allow some facts out there, you know, that case that Elliot talked about, we don't need to be completely ignorant of the facts in our jury selection. But if I could articulate why I was asking these questions to uncover biases and motives and ability to be fair, then I was in a really great position to start asking questions like, hey, who in our community, and I always use the we, the us, the our community, right, because we're all in a community together, who in our community do you think is most vulnerable to being a victim of crime? Right? So all of a sudden we're talking about victims not as victim versus offender, victim, you know, pressing charges. We're talking about a vulnerable person, right? So how do, you know, and you're going to get people to say children, women, then you start playing with that a little bit, okay? Who else? What do you think about, you know, the homeless population? And then you can start thinking about why are they vulnerable? Why would an offender pick them? And then you can get to the point where you're getting people to think about, well, they're picking them because homeless people aren't going to go to the police. Homeless people aren't going to, you know, get services. They're not going to be able to participate in a prosecution. Who knows, you know, if they're being transient or something like that. So all of a sudden, you're sort of started laying some groundwork. And it doesn't need to be your exact fact. But like Charla said, all we're trying to do is get shared experiences out there so that our jury is connecting to our victim in a way that is, you know, outside of I have to be an immigrant and a victim of domestic violence to get this victim. I get this victim because I understand what it feels like to not be empowered. I understand that my friend once told me a story about how she didn't think she could report to the college when she was sexually assaulted because he was, the offender was a football player. Whatever it is, we're trying to bring out shared experiences that can explain some of these things. And offender-focused themes are a great way to come into it with a plan, right? So another thing that we're always happy to help with and try to help you guys build those things as well if you're having trouble figuring out where your case or what your facts are going to lead to when it comes to jury selection. And, obviously the theme is continued throughout the trial. If the glove fits, if the glove doesn't fit, you must acquit, right? What do you think those jurors went back into that jury room and deliberated? What was just replaying in their head? That theme, right? So if we can take that power and for our benefit through this process, we're going to be in a really good position. Okay, that's my soapbox on offender-focused themes. I love figuring them out. The cheesier, the better. Always feel free to let us know. Okay, so we do have a couple of panel questions that Mike's going to lead us through. But as we do that, we really want to encourage you guys to also be putting your questions in the chat box. Rocio is going to be kind of monitoring that, and Michael. But Mike, if you're still there, I know you're having some tech problems. If you want to help us through this next section on the panel discussion, that would be great.
Definitely, yes, and that was a really great presentation and information there. And, as I listen to you guys and I think about, law enforcement and what are some of the things what role can we take? Like, what are some of the things we can do to assist with this process? And, I always think about just going back to the report. I mean, when we're doing our investigations, whether you're a patrol officer or somebody working in a specialized unit, we've been teaching for a lot of years when we talk about domestic violence report taking and writing about including the history and information, and these aren't 4 or 5 line reports. And here's just another example to add to the immense amount of examples of why that's so important, when some of that information that's provided in there might not be, pertaining to actual charges you might be taken out against an individual, but it certainly is information that could have a drastic effect on the process that you may take as a prosecutor when you're doing this, and understanding what this person's been through, what some of the things are that might come out during the course of the trial. So I guess I would just offer that, and being selfish would just ask you guys to fill in any of the blanks that you think, where you have experienced or see where, the law enforcement officer, the investigator might really have a role in helping out with this process. And the other thing that maybe isn't necessarily as impactful to the actual process of doing this, but is very impactful on the victim or survivor, the person that's, going to, potentially be in the courtroom, is we do a lot, over the course of my career, I've done a lot of kind of sitting with the victims while the prosecutors were doing things like this. And although you guys do, in my experience, a very good job of informing the victim throughout the process, this is the way this is going to go, this are the things that we're going to do. But, if we have the time to be able to sit in the prosecutor's office, sit in that waiting room area when things like this are going on and answer questions and provide information, I think it can make a really big difference for you guys, when you move forward. So I guess I was really happy to get some words out, so thank you. If you guys want to respond to that, and we'll go forward on the questions for everybody else.
Yeah, I do want to follow up on that. Oh, go ahead.
No, Elliot, go.
Mike, I would just ask, and I'm so glad you brought that up, because I should have mentioned this before. I always included law enforcement, my detective, my lead agent, in the voir dire process. I was allowed to, in Virginia, we were allowed to share the jury list with our law enforcement officers. So I always shared it and said, hey, look, if you have identified, if you see something on here that I should know, or if you know somebody, because they're more likely to know somebody in the jury than I was. People pay $30,000, $40,000 for jury consultants, and I don't have time for that garbage. But I would love to hear from a law enforcement officer who grew up in the community and say, hey, looking at this person's address or looking at where this person works, I can tell you, this and that. I don't know, Mike, if you've ever done the same thing before.
Yes, I'm so happy to hear that from you, because I wanted to say it, but I wanted to see, how your feelings were around that and how that was going to come out. Because, yeah, when you mentioned, like, Google's a powerful tool and all this stuff, well, yeah, we're like walking, talking Googles when it comes to your jury pool. Majority of the time, I mean, people, and you have access to information through other folks that you might work with and stuff. So if allowed, giving us an active role and at least just taking a look, and, I might say, geez, you know what? You might not see it where you are, but there's some information that might be important for you as far as that person sitting on the jury. And I think it's powerful if allowed,
I also wanted to add...
Go, Charlotte.
Another person that you should add to that team is your victim's advocate. Our victim advocates would often sit with us, or sit in the courtroom during jury selection and watch our jurors as they were asked the voir dire questions, and then, privately give us input. And so while we're trying to manage everything that's in the courtroom, our victims advocates will look at our jurors, read their body language, who's with you, who's not with you, who you should ask more questions of, and I don't know, maybe we just have the best victims advocates in Georgia, in the world, but invariably they've been a great part of our prosecution teams.
That's great. All right, so a question for Elliot. In more conservative jurisdictions, how can you advocate for the judge to ask more questions or include more in a questionnaire? Thoughts on that?
Yeah, Mike, and I'm glad you asked that question, because I mentioned before, teaching voir dire is a little hard when you have, 51 different jurisdictions. But really, I mean, in reality, when it comes to voir dire, you don't have 51 jurisdictions. You have 5100 or 51,000 jurisdictions. There's no such thing as, in some ways, there's no such thing as voir dire in the United States. There's voir dire in Judge Jones's courtroom in the town of Marion in the state of Ohio. And so every judge is going to have their own little rules. And the quote that Jane started with tells us that it's been that way for, at least 150 years, if not longer, in the United States, that's how the Supreme Court and how the system sort of envisions it. The judges have a lot of local control over voir dire. So because of that, the short answer to your question, Mike, is baby steps. You have to educate your judge just like you're educating your jurors. And, I think about that incident with the juror in my federal case, the jurors who raised their hand and said that, people who are not here in the United States are not entitled to constitutional rights. And so we focused on one particular juror because he really raised his hand and was like, he had this look on his face like, yep, they don't deserve any rights. So we talked to that guy a little bit. And, pretty clearly, and he was very open about it. He just said, I don't see why, if you're not here legally, you're entitled to any rights. And I remember the judge was really sort of horrified and reacted very viscerally, which he was not known to do. He literally, well, not literally, but almost literally threw the guy out of the courtroom. I mean, just yelled at him and put his hand and just told him to leave, get out of my courtroom, get out of my courthouse. And the guy kind of looked at me like, what am I supposed to do? And I said, you should leave right now. You should just turn around and go, because something bad's going to happen if you stay. But I don't think the judge had seen that before. And so, again, you're always trying to uncover these biases and illuminate things that you might not have seen. And in seeing that, and the judge seeing that, I think is an opportunity to educate the judge. But when you're uncovering, again, the goal here is not to find people who don't know anything. The goal here is to find people who are not willing to listen to the facts as they hear them in the courtroom and the law as they're instructed by the judge. And so when you have somebody who has a piece of knowledge that is going to prevent them from judging the case based upon the facts they hear in the courtroom, they work with somebody who is an immigrant, and that person, was able to move, was able to buy a house or buy a car or whatever according to what they understood. And then, they're wrong about that, but you have to correct that. You have to fix that because that information is going to affect them, right? Again, your choices in that situation where they have a bias are either to strike them for cause right there or rehabilitate them. And judges, generally speaking, don't like to strike people for cause, I think, and that's going to be universal because there's just only a finite number of jurors out there, especially when you're covering immigration issues. You start striking anybody for cause who has anything remotely approaching a bias about immigration, you're not going to be jurors left in your jurisdiction probably. So what you instead can say is, Judge, I want to try to rehabilitate this person, which will make the judge happy. Oh, that's good. We can still keep them. And your rehabilitation of that person becomes an education for that full jury. Does everybody here understand that, a person who doesn't have lawful status in the United States can't own, can't legally go out and buy property? A person who's not lawfully here in the United States, they have a limited choice about where they're going to be able to work. They have to find somebody who's going to employ them, who's willing to disregard or, essentially not provide information to the federal government. And so you've got limited choices, and you might have to, if you're going to support your family and keep your children alive and feed them and have a roof over your head, you might have to make some really difficult decisions, right? You're rehabilitating that juror. You're doing what the judge wants you to do, but in the process, you're also educating the entire jury. And so you can do that again with the U visa and the T visa, right? And rehabilitating a juror who might think, oh, this person's getting citizenship in exchange for, telling the police something. You can rehabilitate them by explaining, do you understand that U visa is not citizenship? It's simply temporary protection from deportation, and it doesn't even give the victim the right to work at this point. Do you understand that, once the case is over, no matter how it turns out, no matter what you decide as a jury, it's for the Department of Homeland Security to decide what happens to the victim, and they do their own investigation. That what you do in this case as a jury isn't going to change what the Department of Homeland Security does. They're going to make their own decision. Everybody understand that. Judge, see, what I'm trying to do here, I'm trying to rehabilitate this person. I'm trying to make sure this person can still serve as a juror, so we can still actually seat a jury today, and we can actually have a trial like we're planning to. So see, you and I are buddies. You and I are on the same team. Look at how I'm trying to help you out, right? That's a piece of advice that I guess I could share with you.
Excellent. Thanks very much. So moving on, a question for Sharla. How much you use, the members to educate each other about domestic violence, sexual violence, and stalking, to utilize them to do some of the work for you? Could you talk a little bit about that?
I can. I talked about it a little bit at the beginning, but basically what you want to do is to make it something that everyone can relate to. And you do that by asking direct questions. And it might even be general questions about violence. Has anyone ever been a victim of a violent crime? Has anyone ever had to call the police? And then exploring what happened based on if you called the police, what happened? Or were you afraid to call the police? Or did you have reasons for not calling the police? And if you didn't call the police, what were those reasons? And when you have a juror that says, I didn't call the police because I didn't think anything was going to happen, or I didn't call the police because I was afraid that I would be retaliated against, this is something that's also a common theme in domestic violence, which all jurors can relate to even if they haven't been the victim of domestic violence. For example, in a stalking case, you would ask questions about someone getting unwanted attention. Has anyone ever had unwanted attention from someone? Has anyone ever, how did you handle it? Did you feel that because it wasn't violent, you felt like you could take care of it on your own? Or has anyone ever been in a position where they had unwanted attention and they couldn't make it stop? How did they handle it? These are introducing jurors to those themes that are going to be in your case that they can relate to. That helps to educate other jury members. Another thing that you want to do is, and the reason that you're asking those questions is you want to show that it's not rare. Defense attorneys are going to try to present this case as if this is something that doesn't happen, that it's not common to every victim. But if you think about the stats of 1 in 4 women and 1 in 7 men being victims of domestic violence, you're going to have some victims on your panel, or someone who knows someone who's closely related, or someone who grew up in a domestic violence home. And just asking those questions directly will help to resonate with other victims of domestic violence. And try to, when you ask your questions, try to slip in. Domestic violence is very common in our society. Do you know someone who's been a victim of domestic violence? Another thing you want to make sure that you do is because of the topic, you want to make sure that you give people who don't necessarily want to speak publicly about their experiences, which is also going to be very common, make sure they understand that they can be questioned individually or they can be questioned outside the hearing of other jury members, and that will also allow them to open up more for you.
That's a really good point. Thank you.
Sorry, I'm gonna butt in here because you just triggered a couple of thoughts of mine, Charlotte.
Okay.
Number one is we have been hearing across the country that, and for a while now, that victims of sexual violence in particular are disclosing their victimization for the very first time to anyone in the process of jury selection. It has become so common that there are jurisdictions around this country that ensure there is a victim advocate sitting outside of courtrooms where they know that jury selection is happening in a sexual violence case. So something to put out there, and how you want to think about doing that and setting up some sort of safer space. Like you said, Charlotte, making sure the jury, that your judge is on board, that if somebody identifies, because a lot of times what will happen is, there'll be some preliminary questionnaire that is done before the actual live questioning, and something may come out in the questionnaire. And how are you going to address that then later on and follow up on it? So having a game plan when you have a case involving sexual violence in particular, because, and then the other thing to be thoughtful about, because this was a pretty scary case out of New Hampshire, where post-trial, the defense went back, identified the jurors, interviewed the jurors, and came back to the court and said, the jurors that sat on this jury did not disclose that they were victims of sexual violence, and they were, in fact, victims of sexual violence, and therefore this trial was unfair, and the case was reversed. And when we looked at that case and sort of tried to figure out, there's a lot I can talk about that, but the piece that came up, because the judge came back, had those juries come back to his court and questioned the jurors. And kind of along the line, the jurors all sort of said, well, I didn't think that question applied to me. Because the question was, were you ever a victim of a crime? And they said, well, in my head, I never reported it. We never went to the police. Nobody was ever arrested. So I didn't think that question applied to me. And so coupling this conversation, Charlotte, with the question that Elliot was asked about sort of questionnaires, we kind of went a different angle with that, but the use of questionnaires and the language that we use could be very important, because we are getting defense attorneys who are proactively trying to discredit potential jurors because of their victimization. And so just thinking about that, just because you are a victim of sexual violence does not make you unable to sit on a jury, right? There are follow-up questions that have to be asked to actually demonstrate that that person, because of their victimization, cannot sit on a jury for this type of crime, because that victim has now said, I cannot be fair. I would think of that person as the person that did it to me, right? So I think I've gone on a little tangent, but it really prompted me, some of the things that are coming up, because not only did this come up in New Hampshire, but in the Weinstein case, it also came up, and I can't remember which reporter it was, but there was an article that came out because of this whole idea of, if you are a victim, does that mean you can't sit on a jury? And the answer is exactly how you guys have been talking about it, which is maybe, right? But you can't. It's not a yes. Just because you identify as a victim, you are no longer able to sit, right? So, Charla, the way that you said, you have to ask these follow-up questions, not only to educate others, but also to make sure that that juror is, in fact, unable to be fair and impartial. That the standards that Elliot really does a good job of laying out.
Right. You have to really.
What's that?
Sorry. You have to ask that cleanup question. You always have that cleanup question. Notwithstanding everything that's happened to you, or what you know as a victim, or what you know based on your friends or neighbors' experience, or whatever. Is there anything about that experience that in this case would prevent you from being fair and impartial in this case?
Yep, exactly.
Whether you thought it was a crime or not a crime or anything like that, what keeps you from being fair and impartial? And that protects your record.
You may also want to take a look at how are those questions actually written in your questionnaire. If you're in a jurisdiction that has a questionnaire that has that type of question, perhaps it's something that you want to go back and say, hey, maybe we should flush this out a little bit and use different language, or use, a follow-up phrase that says something like, this means whether this crime was ever reported to police or not. But just, some of these emerging issues that are coming up. Okay.
Excellent. Good point. So, Jane, I want to ask a question to Jane. Jane. So when doing this, how can you introduce the U visa without being accused of pre-trying the case, with that being an element of the case that you're trying?
Yeah, and I think this is going to be your defense, right? When you start talking about the U visa, your defense attorney is going to say, they're pre-trying the case, or that was how it was would have been done in Miami for me. But the concept is the same. Every time we sort of want to talk about a specific detail of our case, rather than broader concepts of the constitutional fairness things, the defense wants to sort of cut us off, in my experience. And so we need to be prepared, right? And so I think Elliot gave a couple of general tips that are great, which is come do the baby steps and then try to explain to the judge why this makes the judge's life easier, right? So in this case, it's good to have on hand some case law that talks about biases. There's a case out of Washington State, which actually led to them sort of changing their evidence code. And it was a civil case, but it involved two trials. One trial where the jury knew that the victim had an immigration issue, and the other trial they did not know. And both trials, the jury found that the defendant was at fault, and one jury awarded the victim no money, and in one trial the jury awarded the victim, I'm making this number up, but let's say $2.2 million. So that really demonstrated and led to some changes in the law, because it became very clear that this immigration status did affect jurors. And so you could use that as an argument to bolster your position that talking about immigration, talking about victims applying for or receiving some sort of real or perceived immigration benefit, that these are things that go to the heart of jurors' potential bias and prejudice. And so that keeps our case cleaner. And so I also think that judges don't know what a U visa is, just like a lot of people don't know what a U visa is. Even if we have a general concept, I think there are still just a lot of myths and misconceptions out there. So this is something that you want to be thinking about, bigger picture. Let's litigate how we're going to talk about the U visa in pretrial motion, right? If we can help you guys even brief something, we would be very happy to work with you to do that, to talk about what the U visa is, how it's going to be introduced, potentially even using an expert witness to talk about what it is. But I think you can, without even going there, you can talk about it. We usually did it in the same way of sort of like education, right? One of the things I want to educate about. So, would it surprise you, any of you in this courtroom, that that there is a form of a temporary visa that our government gives to victims of crime, because we want victims of crime to be able to report crime to the police? Does that surprise anyone? And so you're going to get probably everyone surprised. But remember, you're the one, and you may even get an objection, but you're the one that's now framing what that visa is. And so how you framed it is not, did you know that victims, if somebody comes to the police and says they're a victim, they get to like stay in America forever. Like that's what that's what the defense is going to want your jury to think, and that's probably what your jury is going to think because they have no idea this exists. So laying the groundwork through some maybe pretrial motions that are pertinent to evidence of your case, maybe even talking about bringing in an expert so your judge is educated so that when you start asking the questions in voir dire, they understand that this is going to the heart of recognizing some bias out there and recognizing that there are going to be jurors that if they don't know about this, and if you haven't asked them this, that they're going to have jurors that are going to immediately say, I don't believe this victim because. And so it's sort of like the baby steps to get there and then thinking about how you're going to present it, right? You're not going to present it as, hey, is there anyone here that doesn't want victims of crime to get a free pass on their immigration? You're going to have your whole panel raise their hands. And like Elliot said, it's already hard enough to get a panel. Let's not help them get themselves off the jury, right? Let's do a little education first and then ask, now knowing that the government developed this U visa to help law enforcement, now does anyone have an issue with it? And you're going to have the two parts of education, and you're going to have less people knocking themselves off the jury that don't really need to be knocked off the jury because it really wasn't a bias. It was an ignorance of what a U visa was. Hopefully that helps.
Another thing, I'm just to piggyback on what you're saying, even doing that, having that in Georgia we use motions in limine to allow you to present evidence about the U visa because it's relevant, knowing that the defendant's going to use it to attack your victim's credibility. This way you can get an idea of what the defendant's arguments are going to be about the U visa and hash them out during that motion preliminary. And then that can help you to structure your voir dire.
That's great.
And they won't be expecting you to do that. Because they don't expect us to work hard. The working hard is how you win.
All right, so good conversation. I'm loving it. Let's go to Elliot. Elliot, what can you do if you notice that the defense is striking all your potential jurors with Hispanic last names? Elliot?
I see in the notes that he got cut off and was back again. Maybe he's not.
Oh, I wasn't looking at the notes because I made the screen big.
Oh, here we go. How about now?
Sorry about that.
Am I on now?
Yeah,
there he is.
We got you.
We can hear you now.
Okay, excellent. Outstanding. Thank you. So this is one of my favorite things to do, which is to turn the tables on the defense and do something they never expect. Because you kind of watch them flummoxed. In the drug case, in the drug world, it was to, Frank's motion just to kind of sit there and say, hey, judge, hey, defense burden, they got to put a witness on. And they kind of look at you like, what? I have to do something? And that is, Batson tells us that it's the juror's right to sit on a jury. It's not the defendant's right solely to decide whether or not to challenge abuse of the jury selection process for racial or discriminatory purposes. And the defense has no more right than the prosecution does to select jurors based upon impermissible factors, including race. The defense has no right, and in fact may have reasons, tactical reasons why they want to keep Latino jurors off the jury, for example, but they have no right to do that. And if they do that, if they're doing that, it's impermissible under the Constitution. It's a violation of the jurors' rights. And fortunately, the way that Batson and the rules work, and this is pretty universal, I think, across most states, because it's a U.S. Supreme Court ruling, is that if you see prima facie evidence of racial or other impermissible discrimination, you can bring it to the court's attention and say, Judge, look, the defense is systematically striking, even using peremptory strikes, systematically striking Latino jurors, and I'm challenging that. I want them to provide a reason for it. There better be a reason other than the race or ethnicity of the jurors they're striking. And then that burden at that point shifts to the defense, and they better have a race-neutral or ethnicity-neutral, or if they're striking women from the jury, a gender-neutral reason for striking the jurors. And so keep an eye on that. Don't let that happen. Don't feel like that's only something that you have to worry about and not the defense. And there might be reasons to do it. There might be reasons, there's certainly reasons why the prosecution might do it. My first jury trial, I didn't know who to strike. I didn't know what I was doing. I was an idiot, and I just like a trespassing case. So I literally just picked the name off a list, and unfortunately, I picked the only African-American person in the entire panel. I literally was just like, I don't know who to strike. I can't figure. I'll strike Miss Alston. It's the first name on the list, Alston. Well, it turns out Miss Alston was the only, and then immediately I was like, oh, what? Nope. That went badly. Judge, just let me take it back. I'm sorry. I was just picking the first name on the list. I don't know what I'm doing. And I've already, violated the Constitution in my first 5 minutes of my first jury trial. It went really well. But don't let the defense get away with that. And so that's what you would do, Mike.
Excellent.
And I do
Thanks
want to
very
say,
much. Appreciate
Elliot,
that.
thanks for putting together the slides that are there for download, but in that voir dire-generally.pdf, there is some of that Batson case law in there that could be helpful for folks that are less familiar with how that works, especially from the position of the prosecutor. So thanks for providing those to us.
Can I just add one thing, and that is make sure you have your numbers right before you make your argument. No.
Yeah, absolutely. You need to be on good. You need to be on really good grounds if you make that accusation.
Right. I had a defense attorney make that argument on me recently at a trial, and the numbers weren't right. And so you don't want the defense taking the wind out of your sails. So just make sure that you have your numbers.
Excellent. Thanks. Okay, so moving to Shala, how might you try talking to the jury about the fact that the victim will be using an interpreter during the court proceedings?
Okay, so there's two things that you want to think about when you are going to be using an interpreter. First, you want to understand if you have jurors on your panel that are native speakers of that language. I think Elliot brought it up earlier. There are many different dialects of a foreign language and many different idiomatic expressions. And what people understand something to be translated as may not be what your victim is communicating. And so first you want to identify people who are going to, first of all, accept the translation of the interpreter even though they're native speakers of that language. And so the other thing that you want to do is identify those jurors that will have difficulty receiving translated testimony from an interpreter. Some people can handle it, some people cannot. You will want to ask that bias question. Is there anyone that has a bias against people who don't speak the English language? You've got to be direct. If you can't ask that question directly, do you know someone else? You might want to ask the question, do you know someone that is not a native speaker of English? Do you have any feeling, do you feel that official business or business that comes before the court should always be conducted in English? And if you have do that process and you identify those people who have a bias against people who cannot conduct business in English, in the English language, you might want to consider using one of your strikes on them if you're going to have a problem with you using the interpreter. Is there anyone who would not trust the translation of an interpreter? That's another way to, sometimes people have conspiracy theories around translations. You want to identify those people. But basically, you want to identify people who are going to have problems with using an interpreter. You want to identify those people who are native speakers of the language who may not accept the translation or may put their understanding of the language before the understanding of the victim's language. And then you want to identify those people who may have bias against people who do not speak the English language. So those would be my 3 tips.
Excellent. Thank you very much. For the day. And last but not least, Jane, what are some of the strategies you could use to introduce the idea that the victim may have been less than cooperative at some point during the investigation and subsequent interactions with prosecutors?
Yeah, I don't think we have time for like a full discussion on this, because of my previous interruptions. But I think that we can go back to a lot of what Charlotte was talking about, which is using the jury to sort of educate themselves about this and talking about those shared experiences where we have been unable to be consistent in how we respond to something over the course of years, or where we've met victims, or we've have friends and neighbors and relatives that are victims that have gone through the roller coaster, which is usually the traumatic response to such criminality. Add on to that probably that layer of the additional things about when somebody's an immigrant and where maybe the offender is the primary breadwinner. They're the only one perhaps even being able to legally bring in any money to the family. Children that are U.S. citizens, and so deportation is that much more of a threat. So I think we want to be really clear about how we are going to talk about that roller coaster of somebody being cooperative and then not cooperative. And it may be that they got connected to an immigration attorney and that became cooperative after they learned about this form of relief. And I think that goes to sort of the heart of not being afraid of that and having that conversation. And I hadn't quite heard the analogy like Elliot said, but I think it is something that we could definitely sort of take from our work, where it's very common that we're flipping defendants and people are getting deals, and we're all very used to talking about the fact that that cooperation with law enforcement and prosecution sometimes has a benefit. And the reason that that is set up that way is because we want these offenders. We want our ears and eyes to be able to get law enforcement to identify these really dangerous offenders in our communities. So if we can come up with a strategy that sort of gets us back to that offender focus, right? The offender is the reason why this victim was unable to participate at different parts of the history of the case. Then we're going to be really well positioned moving on to the trial itself.
Thanks, Jane. Jane, thanks. Really, really well said. This has been a really good 90 minutes. Great conversation. Really important stuff that we don't always get to hear and talk about, especially in a platform like this. So thank you very much to everybody on the team for being available and having this discussion. Everybody that is on in the chat box from all over the country. I hope you got as much out of it as was intended. New app, thank you. Great job by New app. Giving us the opportunity to do this, and OVW. And we didn't take many questions from the chat box, and I'm sure there's a lot of thoughts out there and a lot of things to add to this, and maybe questions around this topic and others. Please don't hesitate to reach out to New App. There's a phone number, 202-274-4457. That's on the slides. Also, a New App at wcl.american.edu on the slides. Jane's email is on there, Jane Anderson at equitasresource.org. But any questions around any of this, any of the other roundtables that we've done, any comments, any suggestions, please reach out. We do a ton of technical assistance. Everybody on this is a part of the training team, all the presenters, and we have others as well that are available to help guide you through some issues, some barriers, just have conversations about some strategies, all the above. So definitely take advantage of that. I'm on the team, and I've taken advantage of that a couple times, and has made a world of difference in a couple of hot situations that I had on the fly in making some things happen and protect victims. So I just want to make sure everybody's still on the same page with that. We talk about it every time. And a very special thanks, obviously, to the National Council of Juvenile and Family Court judges. Daniel, thank you. You guys do a great job of making everything run smooth, and we really appreciate that. So I don't think we have our date set up for our next one yet, but we'll be putting out an email blast unless somebody else knows the date. I've been a little bit preoccupied with some stuff, obviously, but I don't think we have it yet, but we'll be email blasting it, and we really look forward to seeing everybody again on that platform, on this platform, when we put that out. So be safe, everybody. Stay healthy, and look forward to seeing you at the next one and getting out on the road sometime soon and being face-to-face talking about what we can do to make a difference. Thank you.
Thanks, everyone. Thanks for the work you guys do.
Thank you for having us.